in order to discuss the requirements of the code and, importantly, best practice for compliance, I spoke with John Spencer, Director of Spencer's Solicitors. Firms that enter into fee-sharing arrangements are subject to the requirements of the code. What sorts of behaviour are likely to indicate that the outcomes in Chapter 1, for example, have been met?
I think the key issue is really the provision of information to a client, information about their options and choices, information about any fee arrangement and how it works and impacts them, information about specialism if relevant. So I think it's all about information and recording in writing, preferably. I would suggest your advice to a client if given verbally.
And what about Chapter 9?
I think again it's a similar issue again with Chapter 9, because you're talking about fee sharing and the referral arrangement, and again it comes back to what are you advising your client, why is it good for them, what are their other choices if any, and I think your client's best interest is preserved really by making an informed decision, knowing all their choices, knowing why you are suggesting a particular firm or referral. I think independence is a key. If a client understands what payment, if any, is being made, if they understand the credentials of service and professional excellence and so on that are with the referral source, as it were, they're then informed to make a judgment as to whether they want to follow that advice or not.
Do you have any examples of where you've had to change arrangements because you've had concerns?
We do, in terms of some of the arrangements we've had in place in my practice, which is a personal injury practice. We have to use medico-legal agencies, cost draftsmen and so on, and there are arrangements that can be suggested by third parties, and we've had some service concerns over both of those areas of service, which have in fact led to termination of those arrangements and putting in place new service providers. Why? Because we didn't feel our clients were being best served by the service provided.
So if the rules are not adhered to, what are the consequences?
There is a potential disciplinary sanction by the Solicitors Regulation Authority, or possibly by the Legal Ombudsman, which could impose sanction upon a solicitor who's breached.
Which obviously we want to avoid. So looking at private practice generally, if you were advising a firm who were accepting introductions from another firm, what steps should they take to ensure compliance?
I think they should take steps to ensure that the source is reputable. They should take steps to ensure that there's been no breach in terms of marketing or publicity breaches, or perhaps data protection breaches which have led to the instruction coming to you. Those to me are the key inquiry points, really, the reputation and any matters relevant to how the instruction came to be with you.
So how do you know if your clients are happy with the service that they've received?
Most firms, and mine included, send out client survey questionnaires. I think it's important that those questions posed are real questions that give you information which can help you improve and spot problems in your practice, as well as tell you where you're doing well. And I think that is a key element of finding out how you're doing, and also making sure you analyse as a practice what comes back from clients. For example, we as a board look down and evaluate client survey questionnaire results. We look at what's being said, what areas we can improve upon, what areas we're doing well, and we try to feed that back within the practice.
And so assuming now you're advising a firm who are looking to make introductions to another firm, what steps should they take to ensure compliance with their obligations?
I think they should take steps to evaluate who the best referral source is. They should look at ability to provide the service in question, any issues of geographic and other convenience, perhaps issues of cost and so on, as well as other options that are available to the client, and of course any financial terms that are incumbent on the arrangement that the firm has with the referral source. So I think it's all about information being provided to a client in a fair and balanced way so that the client makes an informed choice.
Now, your advice so far is based on introductions between firms of solicitors, but what about the situation where the third party is a non-lawyer?
I think where the third party is a non-lawyer, the obligations and the advice would be the same. I do think there's a more onerous obligation, however, simply because they might not be subject to a professional framework such as a solicitor, and because familiarity with the service offered may be at a lower level, and there is also the need to make sure in particular that the fee sharing arrangement between the two is clearly understood by the client. What is the service being provided by the third party, and how that is delineated between your service to the client and the service provided by the third party. So I think there's nothing different or radically different from what you would do if the referral is to a solicitor, but I do think some of the concerns need to be heightened really in terms of just how much information you provide to a client. Also, I think it's heightened with regard to the need to due diligence the body that you're referring the client to, and it may not be quite within your experience in the same way that another solicitor's excellence might be familiar to you.
And what if you're advising a self-employed lawyer who is on a fee-sharing consultancy basis? How should they proceed?
I think all of the considerations are the same. There's an added ingredient with an employed solicitor, which is they must make sure that their independence is not impaired, that their professional integrity is upheld at all times, and obviously they've got a relationship with their employer, but they need to understand and demonstrate that that independence is retained, notwithstanding the employed position that they hold.
So obviously whilst they're going to be wanting the work, as it were, they've got to maintain their independence and integrity in terms of the client care at all times.
I believe so, and I think it's just more difficult where you introduce a very important relationship which is superimposed on one's professional obligation. The important thing is that your professional obligation rises above any obligation you have as an employee. You must abide by your professional requirements, notwithstanding any employed status that you've got.
And in your opinion, where do firms fall down when implementing fee-sharing arrangements? What sorts of behaviour are likely to set alarm bells ringing at the SRA?
I think the one key issue going forward will be the delineation between fee sharing and referral fee ban, for instance, which will cause some real concerns, and I think firms will need to be very careful about not inadvertently breaching the ban. I think the other issue which is key is really just the recording of the advice given, so that you've got a reference point for the client primarily, but also to demonstrate that you've given advice on what the fee sharing arrangement is. You've given them options, you've explained why you're referring or introducing this fee sharing arrangement so that a client can make an informed choice.
So you mentioned the ban on referral fees there, which obviously is taking a look into the field of personal injury. Do you think because of the way that the ban is drafted, there's a worry there for firms with fee sharing arrangements in place?
I think largely it shouldn't present a problem because most arrangements, referral arrangements in personal injury, are referral fee based rather than profit sharing based. But if there is a service provided, it's going to be quite important to make it very clear that payment is with regard to the service provided rather than the banned activity within LASPO.
There is the possibility, however, that the ban could be extended into other areas of practice. Is that going to be a concern?
Yeah, the Lord Chancellor has power to extend, and I think we have to just wait and see what happens in that regard. One area, for instance, might be an extension into credit hire arrangements which aren't necessarily directly associated with personal injury arrangements, and one could foresee that there might be an extension there to try to introduce or extend the ban into that sort of activity. So I think it's a question of waiting to see rather than there per se being a problem with a fee sharing arrangement because of the ban.
So you think the future for fee sharing arrangements is safe, at least for the time being?
I think it is. I just think it will be an evolving area, not least because it's already evolving. You've got the statutory provisions in LASPO and you've got the regulator, the SRA, consulting upon how that ban is implemented, and you've got some different views there as to how that ban might be implemented, what it covers and so on. So we've got already we've got an evolving area of legal framework for solicitors.